Hello everyone, welcome again to online session of Manu Law classes. My name is Dinesh Kumar. I'm former assistant professor of law at Campus Law Center, Law Faculty, Delhi University. Presently, I'm working as an academic head of Manu Law classes. So कैसे हैं आप सब लोग? आज हम आपके साथ डिस्कस करेंगे Hon'ble Supreme Court का very landmark judgment that has been recently delivered by Hon'ble Supreme Court in the case of Reserve Bank of India versus Jayantilal N, Mistry and others. Dear students, this case was delivered by Hon'ble Supreme Court on 28th April 2021. So it is a latest case and landmark as well. In this case, I will discuss some of the important constitutional and legal provisions with you in brief. So I'm giving some introductions of these provisions to you. Article 226 of Constitution of India, as all of you are aware, that if we think that our fundamental rights or some of our legal rights are violated, then we can directly approach to Honorable High Court by virtue of Article 226 of Constitution of India. As far as Section 8, Clause 1 or various subclause A, D, E are concerned of the Right to Information Act, this provides for exemptions of the information which cannot be provided under the Right to Information Act. Means, as a general rule, we can seek various informations under the Right to Information Act, but Section 8 is an exception to this general rule. Under Section 8, there are certain informations which a public authority is not bound to disclose. Now we come to Section 10. Section 10 provides that if any information is not exempted under Section 8 of the Right to Information Act, then such information can be taken by any person or any citizen of India under Section 10 of the Right to Information Act. Section 28 and Section 35 of the Banking Regulations Act 1949 authorizes Reserve Bank of India to withhold certain information on the basis of confidentiality, trust, or the fiduciary relationships. As far as the facts of this case are concerned, so before going into the facts, I would like to ask a question from all of you. All of you are aware that we, being the citizen of India, can take informations from the public authorities. The meaning of information has been provided under Section 2F of the Right to Information Act. And any public authority is bound to provide the information. But in today's case, I am going to discuss certain different aspects or some different legal concept. For example, whether Reserve Bank of India is a public authority within the meaning of Right to Information Act or not. Bataiye. Second question is whether information possessed by the Reserve Bank of India with respect to the various banks, including the government bank or the private banks and other financial institutions, can be a public information, or whether we, being a citizen of India, can request or can ask that information from the Reserve Bank of India as a matter of right under the Right to Information Act or not. In my today's lecture, I am going to discuss these legal concepts in detail. As far as the facts of this case are concerned, Jayantilal Mistry is the one of the respondent in this case, and some other persons applied to the Reserve Bank of India to seek certain informations regarding the banks, but under the Right to Information Act. Reserve Bank of India denied this information on the ground that this information is being purchased by the RBI on the basis of fiduciary relationship of RBI and other banks and other financial institutions. So the relationship between the Reserve Bank of India and the other banks and the other financial institutions is of trust and confidence. So RBI is not liable to provide this information under the Right to Information Act. And this information withheld by the Reserve Bank of India is exempted under Section 8 of Right to Information Act. But when these persons approach to the appellate authorities of the Right to Information Act, as all of you are aware about the procedure, now even the Central Information Commissioner ordered the RBI to provide the desired informations by the respondent in this case. But still RBI did not provide any information. Then various writ petitions were filed in the high courts under Article 226 to comply, to order to the RBI that it should comply with the order of the Central Information Commissioner. And what happened? RBI itself approached to Hon'ble Supreme Court that the order of the High Courts or order of the Central Information Commissioner, which compelled the RBI to provide the desired informations, must be withheld and must be set aside. Means RBI ने Hon'ble Supreme Court में कहा कि जो सेंट्रल इंफॉर्मेशन कमिश्नर ने ऑर्डर दिया है जिसके द्वारा कि मुझे इंफॉर्मेशन इस रेस्पोंडेंट को देने चाहिए और लोगों को देने चाहिए, that order must be set aside. So what happened in this case? RBI itself approached to the Hon'ble Supreme Court against the Jayantilal Mistry and others. Now, when the matter reached to the Hon'ble Supreme Court, there were mainly two legal issues before Hon'ble Supreme Court. And the first legal issue was whether Right to Information Act can override certain specific legislations like Banking Regulations Act 1949 and some other acts which provides autonomy to the Reserve Bank of India. It means that whether our Right to Information Act can supersede the provisions of the Banking Regulations Act or some other acts which provide autonomy to the Reserve Bank of India. And second question was that whether Reserve Bank of India can deny the disclosure of such information under the Right to Information Act on the ground of commercial confidence, economic interest, or fiduciary relationship with the other bank. So there were these two legal issues. Now we come to the contentions of both the parties. So first of all, I'm taking the contentions of the RBI, that is the appellant. RBI has taken various contentions, and on the basis of these contentions, it prayed to the Honorable Court that it must not be compelled to disclose the information. So as far as the first contention of RBI is concerned, RBI contended that right to privacy is a fundamental right under Article 21 of the Constitution of India, as it was held by Honorable Supreme Court in the case of Justice K.S. Puttaswamy versus Union of India. So all of you are aware of this case of the Justice K.S. Puttaswamy. So this was contended on the part of the RBI that since RBI is a separate legal entity and this right to privacy is available to every person, including the judicial persons. So RBI should be allowed to maintain its secrecy and it should not be compelled to disclose the information as requested by the respondent in this case. Now we come to the second contention of the RBI. Disclosure would prejudicially affect the economic interest of the state. RBI contended that if RBI will disclose such information, it would affect the economic interest of the state, and it would also affect the market transactions. Why the RBI has so contended? The reason was that because RBI is the central bank of the country, it is the regulatory bank of all the other banks. It regulates all the other banks of the country. So it may have various confidential informations. So information purchased by the RBI, if is compelled to disclose, then it may affect the economic interest of the nation. So RBI tried to protect its informations on the ground that RBI should not be compelled to disclose such informations because it would be against the economic interest of the nations, and it will also affect the interest of the market or various persons who are associated with the banks. Now we come to the third contention. In its third contention, RBI contended that Section 35 of the Banking Regulations Act provides the regulatory power to the Reserve Bank of India. And under its regulatory power, it supervises the various banks upon whom it has the regulatory control. And when it conducts various regulatory activities, its officer may get certain confidential information regarding those banks. And if bank thinks that, means if RBI thinks that such information is in the public interest, then RBI would itself disclose such informations as per Section 35 of the this Banking Regulations Act. But in the present case, the information requested by the respondent was not in the public interest as per the contention of the Reserve Bank of India. So Reserve Bank of India should not be compelled to disclose such information. Now we come to the fourth contention. RBI is exempted under Section 8 of the RTI Act from disclosing such information. I'm discussing here with you some brief informations of Section 8. There are certain provisions in the Section 8 which provides that if the information is relating to the security of the state, if it is related to the unity and integrity of the nation, friendly relations with the foreign state, incitement of an offense, and intellectual property rights, trade secrets, then such information cannot be disclosed under Section 8 of the Right to Information Act. So RBI contended that the information possessed by the RBI with respect to the relations of RBI and the other banks is protected under Section 8 of the RBI. So it should not be, or it must not be compelled to be disclosed by the Hon'ble Supreme Court. Now, the last contention on the part of RBI was that Right to Information Act cannot override credit informations by virtue of Section 28 of the Banking Regulations Act. It means that if there is a contradiction between the Right to Information Act and the contradiction between the Section 8 of the Banking Regulation Act, then Section 28 of the Banking Regulation Act will prevail. So this Section 28 of the Banking Regulation Act prevail over the provisions of the Right to Information Act. So right to information cannot be applied with respect to the information possessed by the RBI in this regard. Now we come to the contentions of the respondent. We have seen the 5 contentions of the RBI. Now I will also discuss with you some of the contentions raised by the respondent in this case, that why RBI must be compelled by the Hon'ble Supreme Court to disclose the requested information as per the respondent. So the first contention on the part of respondent was that since Article 19 of Constitution of India provides for right to know or right to information, so it is a fundamental right of every person or every citizen of India to seek the information. So As all of you are aware that before the enactment of this Right to Information Act, it was held by Honorable Supreme Court in a landmark judgment, that was that the Cricket Association of West Bengal, Information Broadcasting Ministry versus Cricket Association of West Bengal, that right to know is an implied fundamental right under Article 19(1) of the Constitution of India. So as per the contention of the respondent, right to know or right to information is a fundamental right. So RBI must be compelled to disclose such informations. Now we come to the second contention of the respondent. The contention was that all the acts, including the Official Secret Act, can be overridden by the Section 20 of the Right to Information. Now I am giving you some brief introductions about the Official Secret Act. Basically, this Right to Information Act is an exception to the Official Secrecy Act. There was an act, or there is an act of Official Secret Act 1923. By virtue of this act, if any public servant thinks that it is not desirable to disclose such information, then such information can be withheld by the concerned officer under the provisions of Official Secret Act. But Section 22 of the RTI Act provides that even some of the informations can be taken in the cases of Official Secret Act. So if RTI has the overridden effect on the act of Official Secret Act, then it should also have the override effect over the provisions of Banking Regulations Act. And bank must be compelled, or the RBI must be compelled to provide the requested information as per the respondent. Next, the third contention was that as the defense was taken by the Reserve Bank of India in this case, that since Section 8 of Right to Information Act gives power to RBI to withhold the informations, in this case, respondent contended that no, the relationship or the information possessed by the RBI does not fall under Section 8 of the Right to Information Act, because Right to Information Act Section 8 is providing for the different kind of aspect, like the intellectual property rights, information related to the sovereignty and unity and integrity of the nation, friendly relations with the foreign state, RBI, trade secrets, and all these informations does not fall within the protection of the Section 8 of the Right to Information Act. So RBI is bound to disclose that information. Now we come to the decision of the Honorable Supreme Court. Honorable Supreme Court analyzed the contentions of both the parties and came to the conclusion finally that RBI is bound to disclose such informations because of the various reasons. I'm reading the point number 1. Honorable Supreme Court held that the disclosure of certain informations concerning the public interest is allowed if it does not harm to the public authorities. So if we take reference to this particular case, Honorable Supreme Court held that if the information possessed by the RBI is in any way related to the public interest, then RBI must disclose such informations. And if disclosure of such information is not going to affect any public authority. So in the given case, if the RBI would disclose such information, it would not affect the interest of any public authority. So RBI must disclose such informations. Now we come to the second point. Article 19 of the Constitution of India provides that right to know is a fundamental right. So you are aware about that about the fact that right to informations or Article 19 is available to every citizen of India. So in the given case, the respondent is the citizen of India, so he has the right to seek the information. So RBI is bound to provide this information to the respondent. Third, as it was contended by the RBI that the relationship between the RBI and the other bank is of confidence and trust, But Honorable Supreme Court in this case held that the relationship between the RBI and the other bank is not of trust. Rather, it is the relationship of business. And RBI is bound to disclose or bound to uphold the public interest. And RBI is not bound to uphold the interest of any individual bank. So, if RBI would provide these informations to the respondent, it will be in the public interest. And if RBI will withhold these informations, that it will only be beneficial to the individual bank. So if we compare between the public interest and the private interest, then public interest always prevail. So on this ground, RBI is also liable to provide this information to the respondent. Now we come to the next point. RBI has a statutory duty to uphold public interest and depositors. Honorable Court further held that there is the duty on the RBI to protect the interest of public and the depositors. And it is not bound and it is not duty bound to protect the interest of the bank. Because as claimed by RBI, the relationship between the bank and RBI is of confidence and trust. Honorable Court held that no, there is no such relationship exists between you and your other banks. Honorable Court further held that if the RBI will provide such information, it will also increase the transparency in the functioning of the RBI. And a transparency, we cannot say, transparency is not in any way against any law. So RBI is bound to provide such information to the respondent. So finally, Honorable Court held that RBI is the statutory duty of RBI under Section 10 of the Right to Information Act to provide such information. So finally, dear students, RBI was compelled to provide the desired information to the respondent. So that's all for today's lecture, but there is certain important informations for all of you. Basically, we are running certain our flagship courses. At present, we are running 4 courses, and these courses are for different persons and of different durations. As far as the 1-year program is concerned, it is a weekdays program, and this program is ideal for those who are in either class 12 or who have qualified their class 12. So they can seek the admissions in this program for their CLAT examinations. And if the person has qualified their graduation, or they are in the second year of the graduation or final year of the graduations, they can join our DU LLB batch of 1-year program. Now we come to our second program. It is our weekends program. This is 2-year program, and this is ideal for those who are presently studying in the 11th class. So by the time they will come to the 12th class, their preparation will be very fine. Now we come to our program number 3, that is 1-year program and weekend program. This is for those who are presently in the 12th class, and we are also running our same batch for the DU LLB candidates who have qualified graduations or who have dropouts, who have done their graduations, or who are in the final year of the graduation. They can join our 1-year weekend programs. We are also running a crash course of 45 days. This is ideal for those who could not do the preparations of CLAT, and some of the students or all of the students of DU LLB can also join us for our crash course. For getting the admission into these courses, you can contact us at lawentrancindia.com, and you can also email us at info@manoloclasses.com. You can also call us on the given numbers. So that's all for today. Thank you very much.